The Supreme Court has ruled that the federal government does indeed owe insurers over $12 billion. This is a decision that came down on April 27th, an 8-1 opinion coming out of the Supreme Court that agreed that the federal government does indeed owe insurers that participate in the Affordable Care Act marketplace over $12 billion in risk corridor payments. Risk corridors were part of the original risk stabilization measures, part of the early days of the Affordable Care Act marketplaces. The law mandated payments to insurance companies to help balance the risk pool. It was the understanding that if everybody had to have insurance, some markets may have more risk than others. Because insurance companies were essentially guessing at the rates they would be setting in those early days of the marketplace, it was the understanding that some of them may have set rates too low, while others might have set rates too high. For insurance companies with rates too high, there were rebates established with medical loss ratios to help balance the risk in their pool and protect consumers. For insurance companies that set rates too low, there were risk corridor payments to help balance out the risk and make sure that they weren't losing more money than they should have in the early days of the marketplace. Well, the risk corridor was established, insurance companies agreed to take on the risk pools that they did, and the federal government never paid. Hence the lawsuit. In this decision, like we said, it was 8-1. At issue was not just the risk corridor payments themselves, but the reliability of the federal government as a business partner. There was a lot of talk in the opinion about what could have been considered a bait and switch of you promised to take these insured under your wing and we promised to pay. Bait and switch, you took the insured on and the federal government didn't pay. The Affordable Care Act promised to balance payments across the industry to shield that sicker market from this burden. Then there were congressional riders, appropriation riders that were issued barring the Department of Health and Human Services from using taxpayer dollars to actually fund the program. And that's why the federal government said we couldn't pay, we didn't have the money. We made the rules ourselves that said we didn't have the money. The court ultimately decided that the congressional spending restrictions didn't absolve the government of that initial promise to pay. If you're going to be a reliable business partner, you can't change the rules of the game later saying you don't have the money to pay when you said that you did. Justice Alito was the lone dissenting opinion in this one. He called it a massive bailout for the insurance industry, which is what it looks like now. If it would have been paid on time in the early days of the marketplace, it would have been a stabilization measure. Now that it's being paid many years later, it does kind of look like a bailout. But that's not the point. The point was, what did the contract say initially? What was the agreement initially? So looking ahead, what do we have now that the Supreme Court has ruled? Well, we still have other litigation before the court, as you know. Cost-sharing reduction payments are still at issue before the courts, and they use almost the exact same logic as their risk corridor case. They are arguing about statutory obligations and promises to pay. Did the insurance companies, when they agreed to offer cost-sharing reductions to consumers, which is that savings that comes on those out-of-pocket costs, with the understanding that they would be reimbursed from the federal government, and then they didn't get the money, does that have the same outcome as a risk corridor lawsuit like the Supreme Court just ruled? So we'll be watching the cost sharing reduction litigation in the months ahead. And the elephant in the room is the constitutionality of the Affordable Care Act in its entirety. It's before the Supreme Court in its new term, and that new term does start in October. Now, some pundits are saying that Justice Alito didn't want to show any support for the Affordable Care Act, which is why he called this an insurance bailout and didn't want to beef up one of the stabilization measures of the Affordable Care Act. So we'll have a lot of conversation going on as we get closer to that October term of the Supreme Court to see ultimately how people land on the issue of supporting the constitutionality of the individual mandate and the Affordable Care Act in its entirety, or if pieces of the Affordable Care Act can stand on their own to take us into 2021. You can read the opinion in the risk corridor case. We link to it in the description below.